I'm going to talk about this section, which is, in order to be readable, it has to be split into 2 slides. And it is the section that defines incurred expenses in the new SABS. This section did not exist prior to September 1, 2010. It has a history. There is some context, and I think it's important that you understand the history and the context, because as Willie said this morning, there are some aspects of the changes that we are seeing that we have seen before, that we have some experience with, and this is one of them. I think it would be helpful for those of you who have not read this definition to take a little bit of time with me to read the definition before we go into the discussion of it. The important thing on this screen is that the expense, whatever it is, and we'll come to that later, is not incurred unless the insured person has received the goods or services and has paid the expense, has promised to pay the expense, or is otherwise legally obligated to pay the expense. And the second part of the definition, again, incredibly important, that the person who provided the goods or services did so in the course of his or her regular occupation or profession, or sustained an economic loss as the result of providing the goods or services to the insured person. So they have to be doing it as part of their job, or arguably have given up a job in order to do it. Now, this definition is a variation on a theme that existed under the OMPP legislation, and it wasn't as broadly applied in OMPP. It actually only applied to as I recall anyway, the professional caregiver or attendant care benefit under OMPP. But we have some cases. We have some history, and the case that really lowered the boom on attendant care and applied this incurred, the requirement that a professional caregiver be employed to provide the care, was a case called Monachino, and I took that case to trial, and I lost it. And that was a situation where a young man, Silvio Monachino, and I can talk about this because it's a reported case all the way to the Court of Appeal. Silvio Monachino was a brain-injured man who was looked after. He was injured when he was about 17 or 18 years old. His family he had a number of siblings, and he had a very, as you often find, a very caring and competent mother who guided his recovery, who looked after him, provided what we call supervisory attendant care for Silvio for many, many years. And he ultimately was able to regain substantial capacity to function in the workplace. He was able to work as a teacher, albeit on a part-time basis or occasional basis, but he required a good deal of care. The court in that case said that because his mother, notwithstanding that she had no other occupation, was not a professional caregiver, she was not entitled to any compensation or any of the benefit of under the SABS. That was, I like to think, it was a result that perhaps inspired some changes to the legislation. And after OMPP was amended, the legislation did not require that an expense be incurred by a professional or the attendant care be provided by a professional caregiver. It did not require that the expense be actually incurred. The word stood alone. It stood in the legislation in its natural and dictionary definitions, and we had some guidelines to help us understand and interpret what the word meant in the years following the OMPP legislation. Those words, the word incurred was defined and expanded by the courts in its coverage, and it was very helpful. Again, the foundation case that that provides that provided the courts from '96 to 2009 with direction with respect to the definition and application of the word incurred was a case called McDonald versus Travelers, which I was also involved in on this with my partner Ken Howie. It was tried in front of John Osler in 1985. That case, which predated all of our no-fault legislation, involved an accident that took place in Michigan, and the Michigan no-fault legislation was at that time a very comprehensive, extremely generous plan that involved incurred repayment for incurred expenses. So that Justice Osler, who was a delightful man, a very generous and thoughtful judge, provided some guidelines on what the word incurred meant in the context of a contractual accident benefit policy. And those definitions have persisted all the way through to the reinterpretation, the resetting of the definition in these new regulations. Justice Osler said that incurred had a range of meanings, including including run into, which I quite frankly don't really understand, render oneself liable to, bring upon oneself, or be subject to. So it's clear that he felt that to incur an expense didn't necessarily mean having to put your hand in your pocket and hand over money, that simply the promise to pay or engaging in an obligation to pay was sufficient. And in the subsequent cases, the definition was further developed, and the courts applied some tried and true principles of interpretation of insurance legislation, and one in particular, that what's called the contra preferentum rule, which allows a court to look at wording, and if there is any ambiguity in the wording, to interpret it against the party that is proffering or holding it out, and in this case it's interpreted to be the insurance industry. So what it meant was that the courts were instructed by the Court of Appeal in Ontario to interpret wording, and in particular the word incurred, in favor of the insured person where there was any doubt. And that again gave some scope to judges and arbitrators to find that expenses had been incurred in situations which perhaps were not as originally intended by the drafters of the legislation. And finally, the courts and judges looking at these situations, and one of our questioners this morning raised a very evocative fact situation, and many of these have been before the courts over the past 10 years, compelling fact situations, and judges have said over and over again that the legislation is intended to be remedial. It's intended to remedy problems. That's what the legislature wanted when they passed this legislation. And it is purposive. Purposive is another odd word, but I think it means that it's supposed to get the job done. So the combination of these three principles, the allowing the definition to be broadly interpreted, the application of the contra preferentum guideline for the interpretation of regulations, excuse me, and the underlying sense that the legislation is intended to solve problems for people, allowed the courts to interpret this word incurred in a very favorable way for insureds. This apparently, and Willie mentioned it this morning, was not necessarily the full intention of the drafters of the legislation or of the insurance industry, and so we now see a statutory definition, regulatory definition, but the short form is statutory definition of the word incurred, that is imposed upon all of the other sections of the regulations. That means that when you read the word incurred in the SABS, you must read it in the way that it is defined at the beginning of the regulation. There is no more room for the adoption of alternate or broad definitions, and it's narrowed the range of possibilities for judges and arbitrators to interpret the word in a way favorable to the insured, as they have been instructed to do by the Court of Appeal. A number of sections in the SABS are affected. Let me just say that the big change is that it appears that insured persons, if their claims for medical rehab expense or any other kind of expense are denied or are refused by an insurer, in order to claim those expenses, they will have to pay the money out of their pockets and later hope to get it back after a dispute resolution process has been concluded. This was the very problem that the judge in Wawanesa Mutual versus Smith was speaking about when he wrote that paragraph. I'm perilously close to whining here, and I'm going to move on. The definition applies throughout the SABS. The first section is the caregiver section, section 13. I'm lumping it together with the attendant care section, so forgive me for moving on to section 15, medical and rehabilitation expenses. The wording in that section, and this is always the lovely part of a speech where you're actually talking to a large room full of people about the words of a regulation. So if you do nod off, it is in the paper and it will be in the podcast. The wording is, the insurer shall pay for all reasonable and necessary expenses incurred by or on behalf of the insured person. Practically speaking, so just to back up, we then, to that definition under the medical and rehabilitation section, section 15, we apply the regulatory definition of the word incurred that's found in section 3. So in order to be incurred by or on behalf, it effectively has to be contractually, they have to be contractually bound to pay the expense. It's not enough anymore to simply put in a plan of treatment and assessment, as they're now called, and ask for the expense and then proceed to a claim if it's denied. Because if you proceed to the claim, having got over the first hurdle that you must submit a treatment plan and a treatment and assessment plan, if you're denied, the arbitrator may well say to you, because you didn't spend the money to do what was recommended for you, you can't come here to arbitrate this claim because you didn't incur the expense. Now, I'm going to come to a saving provision later that helps, but does not, in my view, entirely solve that problem. That means that the insured person, and in your case, your clients, will have to incur a financial obligation for treatment that they, in some cases, may not be able to comfortably bear. We know from a practical point of view that when a traumatic injury occurs to a member of a household, it very often upsets the financial equilibrium of the household and creates financial hardship and shortfalls. So the additional burden of having to incur obligation, financial obligation, or spend money can be extremely difficult for these people. This is a new and challenging variation on the theme that we've seen in the SABS up until now. Section 17, case manager services, roughly the same wording. It reads as follows: the insurer shall pay for all reasonable and necessary expenses that are incurred by or on behalf of the insured person as the result of the accident for services provided by a qualified case manager in accordance with a treatment and assessment plan under Section 38. There are effectively three requirements that need to be met. The first is that the expense be incurred, and I take you back to the statutory definition of incurred, that there needs to be some obligation that is incurred, some contractual obligation to the case manager. Second, the case manager needs to be a qualified person. And thirdly, that the case management services need to be mandated or have been recommended under the terms of the treatment and assessment plan. There is no problem with two of those three, but the incurred expense definition does create a problem for some families who may be, if case management services are denied or the full scope of case management as recommended in a treatment plan is denied, families may be reluctant to incur the expense or pay those expenses themselves and arbitrate. Possibly the most difficult and challenging aspect of this change is in regard to Section 19, the attendant care benefit. The insurer, the wording there is, the insurer shall pay for all reasonable and necessary expenses that are incurred by or on behalf of the insured person as the result of an accident for services provided by an aide or attendant. Well, we know from the definition that an aide or attendant has to be providing those services in the course of her usual profession or occupation. That means that on the bare face of those words, on the dictionary meaning of those words, you're going to need to go find someone whose ordinary job is to be a caregiver for injured persons. That's certainly how the insurers will, I predict, interpret that section. Or alternately, a person can qualify by having an economic loss as a result of providing the care, which means it's obviously intended to cover family members who give up a remunerative occupation in order to provide attendant care. Now, the reality is that you're going to be looking for someone who provides attendant care as part of their regular occupation, and it is going to be extremely difficult to find someone who will work for the SABS rates, because the SABS rates, in my view, were set with a view to remunerating family members who largely do this work in catastrophic cases, to remunerate them, family members, at a reasonable rate, but not at a professional rate. They no longer qualify unless they give up a job that presumably, one would hope, pays them more than the SABS attendant care rates. They don't qualify to be attendant care providers, so you're left with the professional attendant care providers in respect of whom these rates are simply inadequate. So there will be a shortfall, there will be a gap, and that gap can either be paid for or picked up by the insured person if no alternative to a professional caregiver can be found, or alternately, they'll simply have to do without. Now, there is a possibility that a professional, well, in the Monachino case, we tried to argue that Mrs. Monachino, because she was a mother, a stay-at-home mother, was a professional caregiver. I think that argument persists. I think there's an argument that a stay-at-home parent could be defined as having caregiving as their usual occupation and might qualify into that section, but I think that would be a relatively rare case, and I think we're going to see some cases on that. The only other alternative to, if you can't find a professional caregiver, appears to be that you persuade one family member, some family member, to quit their job, and presumably you're looking for the one who has the least remunerative job, quits their job to take up a new occupation as a caregiver. And in that case, I think we can expect, we will argue that an economic loss has been sustained. The question is going to be, if you find the person who is 2 degrees of separation from the accident victim, who has a part-time job at Tim Hortons earning $200 a week and gives up that job to earn $3,000 a month providing attendant care, I think the insurers are likely to argue that the financial loss has to be commensurate with the income that's being earned through the caregiving. The statute doesn't say, the regulation doesn't say that, but I predict that there will be a balancing being argued by the insurers. Our position will be any economic loss, and it may not necessarily even be a wage loss, is sufficient to trigger the entitlement to be paid as a caregiver. We don't know what's going to happen with that. That will be fought out before arbitrators over the next 2 or 3 years, and we'll get some better understanding of that. Certainly, in that battle, which will be a protracted one, we'll be relying on the rules of interpretation that were developed beginning in the McDonald case in 1985 and by the courts and arbitrators over the past 20 years, 25 years. Now, I spoke of a saving provision. The housekeeping benefits, very similar, very close analogy to attendant care benefits. As we know now, most often these services are provided by family members. The definition of incurred will apply to that benefit, and it will be necessary to find someone whose usual occupation is to provide housekeeping services if you're going to be applying for the $100 that is no longer available for non-cat, but still is available for catastrophic cases. Now, the saving provision, if you take a moment to read it, this is sort of a lawyer's thing because it is likely only to come into play in an arbitration, but I think it's important that you know the end game or that you be familiar with the end game. So it essentially says if you're at arbitration and an arbitrator finds that the expense was not incurred because the insurer unreasonably withheld or delayed payment of a benefit, the arbitrator may be entitled to deem that the expense has been incurred. In other words, he can go in and fix it up if the insurer's behavior is found to be unreasonable. The difficulty with this is that there are now 2 tests that have to be met by the insured person if they're going to be reimbursed. The first one will be that the expense is reasonable and necessary, or whatever the definitions are that we've been through under the various sections. They'll have to meet all of those hurdles to get there. And secondly, they're going to have to show that the insurer was unreasonable in refusing. Now, that doesn't mean that the expense, I don't think that's the same thing as saying that the expense was not reasonable and necessary. I think it has to do with the insurer's behavior in denying the expense or not approving the expense or delaying the expense. That's a process argument, and it will depend on what the insurer has done in the claims examining process and whether they failed to respond appropriately to the claim, used incorrect information, whatever. You're going to have but you're going to have to get through those 2 tests in order to succeed under this saving provision. In my view, it will not be enough to simply establish that your expense was reasonable and necessary. So it is a saving provision. It helps, but it doesn't take us all the way back. Practical strategies, that's what you came here to hear. We have a few of them. I don't think you're going to be bowled away by them, quite frankly, but here they are. The first one's kind of obvious. You've got, apparently we're all related in 7 degrees of separation. I think you're going to need to start to canvass a little widely in the families to try to find someone who can argue that they looked after somebody as a professional at some point in time, preferably now. And they will be your first pick to find someone who will work for less than market rates to provide care. This is something that may be necessary. Effectively, we have always had a 2-tier insurance system. We've always had a set of benefits available to people who are at fault in an accident, meaning the no-fault benefits, and an enhanced level of compensation available for those who are not at fault, who have tort cases. This has always existed. The balance between those two systems has been shifted again with these amendments. And those who are left without a tort case are probably, the gap between those victims and those who have tort cases is probably greater now than it was before. In order to bridge that gap, they may need to negotiate some form of litigation financing that could in part be paid for out of the penalty interest provisions in the SABS, and possibly out of the insured person's own pockets. If they do have a tort case, the litigation financing can be obtained through the financing of the tort case, and there are firms that will do that. We're not recommending it. We're simply saying to you it is an option, and it is now an option that may have to be availed more often than before. If you are your client is one of the lucky ones who has a second-tier availability of a tort case, you can try to negotiate an advance payment from the tort insurer to fund treatment that is necessary but not available, is not being paid for by the accident benefit insurer. And the argument that we use in that case, it doesn't sound quite it's not quite as futile as it sounds. The argument we make in that case is it's to everybody's benefit to make this treatment available. It's to your benefit, defendant, tort defendant, because the person who's suing you is going to be better than they would if they didn't have this treatment. So I think we're all going to have to get a little more aggressive at tapping into the resource that's available in the tort case to try to fund treatments and care that is may no longer be available under the accident benefit policy. And finally, and this gets into a real this is terribly problematic, but it's a possibility. It may be necessary to negotiate a deferral of payment of services, and try to work out, if your client has a tort case, work out a way to repay or to top up the services that have been provided with money from the tort case. Some service providers may be prepared to wait. Some service providers may be prepared to work for SABS rates and be topped up later out of the tort claim. These are things that I think we're going to have to be a little more creative at exploring and a little more aggressive at implementing in order to help our clients. Darcy mentioned in his overview that there are some gaps, and in particular I want to address this issue that is related to incurred expense. Because non-catastrophic attendant care claims are capped at $3,000 a month to a maximum of 36 months, if you're paying out attendant care or tapping into that resource at the maximum, you will have no attendant care available for you for the second 12 months. You're only entitled under the whole body section to apply for catastrophic impairment after 2 years. That process will take 6 months. Just can't be for sure. So you've got a 12 to arguably 18-month gap where you have no attendant care being paid, and because you aren't receiving attendant care, you don't have any option to apply for it. Unless steps have been taken to incur expense at the $6,000 level from the outset to the date of the catastrophic declaration, there will be a retroactive loss of catastrophic benefit totaling $144,000. In other words, there will be the difference between the $3,000 and the $6,000 for the first 12 months, and then there will be a loss of $6,000 a month for the next 18 months, or until the catastrophic designation is approved. Do we have a solution for this? No. Do we need to be mindful of it? Yes, because we can trip and fall. And it's a very substantial loss of the proceeds available under the policy. Those are my remarks on incurred expenses, I'll turn the podium over to Sloan, who is yet to be introduced.
I get to talk about assessment costs and, you know, to do it in a way that's good news, not bad news. In fact, Craig, I think you told me that the only way I was allowed to speak today was if I agreed there would be no whining as part of his directive. So there will be no whining. Lunch is good. It's happening quite soon. I'm told it's very tasty. For those of you who think that you make too much or that you have too much work, good news. You know, there are good insurers, there's bad insurers, there's some that we get along with, there's some we don't. All of them will be more economically viable. That's good, especially those that we don't necessarily enjoy working with. You know, I've lost so many good hours of sleep worrying about some of these insurers that I just love, and I won't have to wake up in the middle of the night in a cold sweat anymore because I'll know they're more financially viable. So more good news. Some of what I say will be repetitive because Darcy and Lenny did such a comprehensive job, and it really was a monumental task to go through all that legislation. But you know, assessment costs, assessment examination costs, $2,000 max. That's it. That's as at September 1, 2010. That's for accidents that happened both before and after. So that's what you're looking forward to. No rebuttal reports. Well, this is good news. This is really good news that there are no rebuttal reports because think about it. The insurers don't have to send your patients out to an IE anymore to deny. So you don't have to read about your own incompetence from a colleague. And you don't have to argue about it afterwards. So this is really good. That's good. Only RNs or OTs can do Form 1 assessments of attendant care. Well, that's good news if you're an OT or an RN, right? You know, I think I got to cross-examine Ms. Rukas over there in a couple months in a case, and she gets to now say, I have instant credibility, you know. I'm one of only 2 disciplines competent to talk about attendant care. So her reputation has been enhanced by this, and so has every other OT or RN in the audience, so congratulations. It's good news. Yeah. No future care cost reports. I don't think that's a change at all. I don't think the insurers had to pay for it before. What they recognized is that catastrophic cases, the only way they were going to have some sense of exposure was to do them. And so I imagine that most responsible insurers will continue to fund them in catastrophic cases. So those are some absolutes, and those are some things that happen as at September 1, regardless of when the accident happened. To understand report costs and assessment costs and how you're going to get paid for the work you do, you have to address the 3 separate injury categories that exist under this new legislation. More good news, there's no more PAF, right? That's good. It's been replaced by minor injuries and the minor injury guideline. That's defined in my paper, but in terms of cost and assessment cost, what you need to know is there's a cap of $3,500. It includes all of the treatment, and it includes all of the assessment costs, $3,500. None of it. There's no attendant care, so don't assess attendant care if it's a minor injury. There's no housekeeping, so you don't have to assess housekeeping. Less work. This is good. You don't have to do all this stuff. And there's no in-home assessment, so you don't have to travel. You know, this is good. They come to you. There's an escape clause that you've heard Darcy speak about. Very cagey. You know, if your patient suffers from a pre-existing condition that will prevent your patient from achieving maximum medical recovery under this $3,500 MIG, then you can get out of it. The MIG being the minor injury guideline, not the fighter jet from the Russian Air Force in Top Gun. In any event, you can get out of it if you have this pre-existing condition. That's great. So the insurer is now going to get you to go do their work for them. These are all the pre-existing conditions that are unrelated to the accident, and now we want to treat them, right? So be careful when you're addressing this escape clause. Make sure that when you're writing your reports, you identify that it's the car accident that's the cause of the injury, but it's these pre-existing vulnerabilities that make it more necessary to provide comprehensive treatment. Don't lose focus of that, because otherwise you'll shoot yourself in the foot. There's non-cat injuries, right? We still have that category. The limit's been reduced from 100 to 50, and it's inclusive of report costs. There's no housekeeping. There's no caregiver. There's no case management. All the report costs, like I said, $2,000 max. I have a couple questions, rhetorical, because there are no answers. Neuropsychs. I know that Dr. Gates back there somewhere, he does the work he does, he gets paid for what he does, and I don't know how he's going to do a neuropsych for $2,000. There's some discussion about, well, maybe we do an assessment with the psychometrist, and we bundle that out, and then we have the neuropsychologist review the data and write the report, and we bundle that out, so at least there's $4,000. But I'm not sure if a psychometrist is a regulated health professional. So I don't know that that person's entitled to be paid the $2,000. Situational occupational therapy assessments. I just had a client deemed CAT only because she went through a 2-day assessment that addressed her needs over the course of time, not an hour snapshot. And the assessment was more than $2,000 because it was for 2 days. I don't know how you have that evaluated under the new system, other than maybe putting your client on a treadmill for the day prior to the assessment and say she got really tired the day before, see how she responds now. CAT assessments. Remember, for many people who are going to be seeking catastrophic determination, they start from the premise that they're not CAT, or at least that's the insurer's premise. Until you're CAT, we don't have to pay CAT benefits. So we got to do this CAT assessment. And is it $2,000 for the CAT assessment, or is it $2,000 for each discipline required to undertake the CAT assessment? And I think Darcy mentioned further restrictions that a CAT assessment can only be completed by a physician unless it's only a brain injury. And I've never seen a case that was only a brain injury, but to the extent there is one, if there's only a brain injury, then that can be assessed by a neuropsychologist. The SABS are silent in terms of whether other disciplines are to be consulted and whether those other disciplines are subject to a $2,000 per assessment cap. I imagine that we're going to see some guidelines about that in the coming months, and we'll keep you posted. But these are issues for which there are no direct express answers in the SABS as currently drafted. I raised a question with Mr. Handler earlier. Many of your patients are going to exhaust this 50, and by the time they're entitled to apply for CAT, the 50's gone. And how do you become assessed? How do you access it if it's to come from this 50? And again, we've heard it. There's no answer to this question other than if they have a tort case, and I'll talk about that in a few minutes. More good news is that we still have CAT, right? There still are people that have suffered catastrophic impairment, and they have access to the $1 million of med rehab and the $1 million of care. And more good news is that the definition has been expanded to include single limb amputees. That's good. That's unequivocally good. Other than that, it's essentially the same definition for now, which is also somewhat comforting. So how do we solve these problems? Well, the easiest way to solve them is if your client has a valid tort claim. Because like Craig has indicated earlier, really what this has been in part is a transference of responsibility to those people who are at fault for your client's misery, for your patient's misery. And in some respect, that's just, okay, as long as they meet threshold and they're not at fault. But there will be circumstances where you will work more closely now with your client's representatives, lawyers presumably that can help you finance some of the efforts that need to be made. By saying finance, I don't mean paying you for treatment. That's something that we can't do. But we can pay for reports. And at Thomson Rogers, I speak on behalf of the partnership when I say there will be appropriate cases where we're paying for your reports. We're paying for more comprehensive reports from the outset to address housekeeping and attendant care entitlements for those people who need those benefits but aren't getting them the accident benefit side of things. There will be occasions when we need to fund reports because it's more likely that we're going to have a catastrophic finding, a catastrophic impairment finding, if we have good evidence. And so there will be occasions when we say, we should be paying for those reports. There might even be a circumstance when we know our client's going to max out the $50,000 non-cat med rehab, and that it's plainly obvious to us, and we might, in certain circumstances, be saying to you, even though some of your report costs can be submitted to the accident benefit carrier, don't submit them to us, because we want to preserve that 50 for med rehab, not report costs. And sometimes, if I get a call from Dr. Gates and he says, Sloan, your client needs a neuropsych, and a comprehensive, a competent neuropsych can't be done for $2,000. It's going to require $4,000. Again, in certain circumstances, we're going to bite the bullet and say it's better to have correct evidence as opposed to incorrect evidence, because it's worse for us to go to an arbitration or a trial and lose than it is to front-end a disbursement for an extra couple $1,000s. I have no solutions for those people who don't have a tort claim or who do not have a significant prospect of being deemed catastrophic. Those people will experience more hardship under the current SABS than they previously did. But if there's a prospect of catastrophic impairment, or if there's a valid tort case, there will be creative ways when working with certain counsel that will bridge the gap and help solve the problems. Okay, it's lunch. Good news. And if you have any questions, please feel free to approach us out in the hallway. Thank you.